Hi, everybody. Just wanted to say welcome and thank you for coming out. I would like to echo what Albert said in that I appreciate you guys coming out and really showing interest in such an important topic. So I think I'm the only person on the panel in private practice. I represent clients in all three areas of immigration. And as you can imagine, the last 3 months have been a blur. I did waive a lot of my fees for I waived the consultation fee for one, so anybody was free to give me a call and ask me any questions they had about the travel ban. So it's been kind of a whirlwind since all of this went into effect. But again, thank you, and I look forward to your questions. I just want to add one point, because at the end you were like, we don't know what's happening to this data. Just from a practice perspective, I've seen tons of clients who registered so many years ago and are seeing a very real effect on their applications now. And these are individuals who may be applying from within the U.S. or even applying abroad. So for example, someone who came on a student visa, registered, abided by the law, departed prior to the expiration of their visa, and then they wanted to renew their F1 visa. I have a client right now who's dealing with this, and they get stuck. And so now their application abroad is, sent into the black hole of administrative processing. And a lot of it, I've personally, and I know attorneys in the immigration bar have linked it to individuals who registered with NSEERS. So we're still seeing a very real effect on these individuals even today. This is a big one. So just like he said, that the immigrant population within the Muslim community feels targeted. What I've encountered even more is U.S. citizens within the Muslim community who are feeling especially targeted and vulnerable in a way that they've never felt before. Even myself, I was born in the U.S., but I was like, thinking about, okay, if I'm traveling abroad, I have to be prepared. This is what's going to happen. So just in general, we've obviously noticed an increased amount of Muslims being subjected to secondary inspection at the airport. So individuals who are traveling abroad, and these are U.S. citizens, these are green card holders, and even obviously non-immigrant visa holders who are traveling lawfully under either a valid visa or a valid passport, and then returning to the U.S., we're encountering questions regarding First Amendment protected speech. And for example, some of my clients, and I know you've heard this as well, is how many times do you pray? And this is all in the confines of secondary inspection at the airport, where there's usually no cameras, there's no attorneys allowed, really. The area of law covering whether these individuals have even a right to an attorney in customs inspection is still kind of murky. Yeah. So that was a tough one on kind of balancing how to give them the advice about requesting an attorney. But questions that they were being asked were, how many times do you pray? What mosque do you attend? Did you attend mosques when you went abroad? Are you a practicing Muslim? Questions that were all protected under the First Amendment, and social group affiliations as well. And so in providing advice, and I know CARE did a program as well that was really helpful, was kind of balancing asserting one's legal rights with being practical about it and trying to refrain from creating a combative environment with the customs officer. So that was kind of where I came from. I would first always lay out one's legal rights, and I think that's the most important thing for the Muslim community and any community really, is to be empowered with the knowledge of one's rights. And once you're armored with the knowledge, I think it's really important to balance that against what the practical implications of asserting one's rights are. For example, unlocking the cell phone, that was a really big thing. Again, the law is kind of murky on whether you have to, put your fingerprint on, finger onto the phone. So although they aren't required to, sometimes, under certain circumstances, the individual was like, well, if I refuse to give my password, the officer is going to hold me even longer. So what do I do? And so one thing that Albert said that was really important was lay out the individual's rights and let them make that decision in the moment. Kind of gauge what the officer, how the officer is interacting with them, and try best to assert one's rights, but in a calm, respectful, sensible way. And so that's kind of the advice I've been giving. But I do want to point out there's a key distinction between U.S. citizens and immigrants and non-immigrants, right? So when they're coming here, they're seeking admission to the U.S., and that's a legal term. So they can be denied admission under any basis. So unfortunately, as an immigration attorney, when I advise my clients, it's a difficult balancing act, because either you give your phone and you're allowed to enter the U.S. and join your family, or you don't give up your phone and you're going to be sent back to the country you just came from. So it's really a difficult decision for them. And notably, individuals who are removed, even though they may not be U.S. citizens, do have a right to a hearing before an immigration judge if they're subject to removal. So before they can be put on the plane, they're entitled to that hearing before an immigration judge. What CBP was doing is forcing them to voluntarily revoke their LPR status, their lawful permanent resident status. So what we were seeing was an increased number of CBP officers kind of coercing, harassing, exploiting, under duress, honestly, these individuals who were vulnerable, just came off of a 20-hour flight, into thinking that because they were overseas for XY reason, or because they were overseas for a certain amount of time, that they had voluntarily abandoned their permanent resident status. And so they, tired, exhausted, they just want to go home, would sign these forms, not realizing that they were giving up, abandoning their permanent resident status voluntarily. And no individual is required to sign this voluntary abandonment. But unfortunately, it was just rampant those first 2 weeks, and so many of my clients were, to-be clients, were signing and just being sent right back home, not realizing that had they not signed, they would be entitled to a hearing before an immigration judge. And this is a direct result of the Trump administration's policy with respect to enforcement. With the executive order on interior enforcement, and then directives that have been issued in the Department of Homeland Security. So there's definitely been an increase in actual raids, which I'm sure you've seen on the news and you've heard about. So basically, the Obama administration had created priorities of enforcement. So individuals who had committed certain violent crimes, had been convicted of those crimes. That's a key distinction. Had been convicted of certain violent crimes, and it would slowly kind of go down the priority list depending on the crime that the individual was convicted of. And then individuals who had no criminal history were kind of de facto not under immigration enforcement. That has been completely done away with. So now, basically, it's just like it's fair game. So any individual who is here undocumented, that includes individuals who entered without inspection at the Mexico or Canadian border, or individuals who overstayed their visas, or individuals who are here validly under a valid visa or as a lawful permanent resident who are convicted of a crime, are subject to enforcement. Now, these individuals may be undocumented and may encounter law enforcement in any number of ways, and then are automatically subject to enforcement. So, for example, one key distinction between the Obama administration's priority enforcement and what Trump has done now is any encounter with law enforcement, you're subject to immigration enforcement. So, for example, if you were charged with an offense but not convicted, if you were arrested but not charged, if you were driving and you got pulled over by a police officer and you happen to be in a jurisdiction that allows them to contact immigration or check your identification documents, you may be subject to immigration enforcement. So in that way, more individuals are at risk of being subject to immigration enforcement. And then on the back end, what we've also noticed is once they're in proceedings, the DHS attorneys are no longer willing to join in motions that they normally would be joining in, for example, like a joint motion to terminate. So what we've noticed, and the Immigration Bar has noticed in the past couple of months, is DHS counsel is really reluctant to kind of do anything in favor of the respondent. So, for example, they won't join in motions. Prosecutorial discretion, which was used very widely during the Obama administration, is kind of off the table. Many requests for prosecutorial discretion are kind of just being left to the side, not responded to by DHS counsel. And these are attorneys who, honestly, in my experience, are kind of in limbo and don't really know what to expect from their higher ups, so they're just not responding to the PD requests, or not responding to a request to join a motion to terminate or join a motion to admin close the proceedings. And so what's happening is more and more individuals are ending up in front of an immigration judge, whereas during the Obama administration, we were able to seek and get approved prosecutorial discretion, and those individuals were able to seek immigration benefits that they were eligible for. Whereas now, even though they're eligible for those benefits, they're stuck in front of an immigration judge. And this is a drain on resources, that has a very real effect on our tax dollars and has a very real effect on these individuals in their lives, where they may have a U.S. citizen spouse, but because they had, they were arrested for some reason or another, now they're in removal proceedings, and even though they're eligible for a green card, they're no longer able to seek that benefit because they're in removal proceedings. And we're in an administration that from the top down does not favor seeking that immigration benefit and protecting these immigrants and allowing them and kind of being a champion for them to continue their lives in the U.S. So those are kind of all the effects that we're seeing. I'm trying to think about what else. Even just in applications for immigration benefits, like I had said earlier, we're seeing more and more individuals, and they just happen to be applicants from Muslim majority countries being placed into administrative processing. Individuals who are dual citizens, this is something recent that I've noticed, who may be a citizen of the UK and a citizen of a Muslim majority country, can no longer avail of the visa waiver program. So even though they applied for the visa waiver program, and what that is it allows nationals of certain countries that the U.S. has pre-designated to apply onto an online program, and they don't actually have to go through the visa process. They can just come through that program. So what we've noticed is applicants who are from a Muslim majority country and maybe a citizen of the UK are now they're being denied unequivocally through the visa waiver program. And more often than not, I've had several clients, even in the past week, I can't get a valid reason as to why they were denied through the visa waiver program. So it's really kind of a huge and dynamic policy shift, where before there was kind of from the top down an atmosphere of protecting immigrants, keeping them in the U.S. through programs like DACA, which is under a great deal of uncertainty right now. There was a leaked order that DACA would be rescinded; it would no longer be granted to new applicants. But right now, it's just a huge cloud of uncertainty. So we've noticed from the beginning all the way to the end, from visa applications to removal proceedings, noticed a significant difference in immigration. And I just also wanted to point out some of the rhetoric I keep hearing is the administration is only targeting the undocumented immigrant. It's only targeting the illegals. But even a fairly new development is individuals who are applying for an immigration benefit, who are following the law, are being targeted. So these are people who are applying for a green card through their U.S. citizen spouse, but may have an old deportation order outstanding. They go for their USCIS interview and they're arrested. So it's, this administration is not just targeting the illegals or the criminals. So it's really targeting anyone. So anyone who just happens to encounter law enforcement dropping off their kid to school is at risk of being subjected to immigration enforcement. And individuals who are really trying to follow the law and really trying to seek that immigration benefit are being targeted in that process. Yes, I just wanted to mention a couple of things. First would be kind of the, pushing back on the narrative. One strong narrative right now is the criminalization of immigrants. So kind of creating this false narrative that immigrants are criminals and criminals are immigrants, and immigrants are these violent offenders, and we all need to, and we only want to get these violent immigrants. We don't, everybody who comes here lawfully with, from El Salvador or whatever is fine, but if you violate the law, if you commit a crime, you need to be gone. So the reason I have an issue with that narrative is twofold. Number one, they are attacking this by lumping in these criminal immigrants is pretty much anyone who encounters law enforcement. Like I said, you could just be speeding and now you're labeled as a criminal immigrant, and you're subjected to those same labels and narratives. So I want to make it clear that when the administration is saying that we're only targeting immigrants who are committing crimes, that is 100% false. And so that needs to be, myth busted like today. And so the other thing I wanted to say is a lot of law students kind of help me out in my private practice. I do a lot of organizing and kind of reaching out to the Muslim community in particular, in just educating the Muslim community on, number one, their constitutional rights, so that they feel, right now the Muslim community, just like the immigrant community, is feeling very attacked and feeling very vulnerable and feeling, quite honestly, very afraid. And so one of, as an attorney, my first gut reaction is know your rights, right? So, one way law students are helping me is kind of, number one, organizing those events. Number two, helping me, like she said, legal research and writing, you guys are great at. And so helping me research, for example, policy on access to your electronic devices and how we can educate the population on how to deal with those encounters and how to encrypt their devices. Also in the line of legal writing, I know in New York City you guys are okay, but in other jurisdictions there's a lot of local law enforcement that are entering into these 287G agreements with ICE. And what that is basically they're saying that they will cooperate with ICE whenever they encounter an individual who's undocumented, i.e. give them a phone call and say, hey, we got so-and-so, he appears to be undocumented, do you want him? ICE, yeah, keep him. Okay, we'll keep him for 48 hours. And then this individual who was arrested, but the police found out it wasn't him, are now going to hold him for 48 hours for ICE. So I've had law students draft statements, requesting local police officers, local government, state government to declare themselves sanctuary spaces, declare publicly that they won't enter into these 287G agreements. And finally, I just, I emphasize a lot just dialogue. I think it's really important that, everybody kind of pushes back on the constant vomiting of false information. And so how we can do that is stay informed, such as through panels like these, and then share that information and disseminate it in your respective communities. I think that's really important to kind of push back on what is constantly kind of being thrown at us, is pushing back with concrete and legally accurate information, and creating dialogue to kind of create an atmosphere where we're pushing back on that. So these individuals are being placed into removal proceedings for minor offenses against the Immigration and Nationality Act, i.e. overstaying their visa. So what would normally not be an offense that would subject them to removal proceedings is now subjecting them to that. So what we had seen is, we're looking at an individual who's subject to deportation, and we're like, this is normally an open and shut. They would never be served a notice, an NTA. They would never be, placed into removal proceedings otherwise. So to us, it's glaring that they were registered under NCERS, and because they're a visa overstay, or they skipped a couple of classes under an F1 visa, now they're being subject to removal.